It was 6:30 a.m. when my security camera captured Patricia Garfield, president of the Pine Ridge HOA, standing at the entrance to what used to be the neighborhood walking trail. She was wrapped in her fuzzy pink bathrobe and slippers, furiously shaking the padlocked gate I had installed just days before. Her voice echoed across my backyard as she shouted into her phone, "This is illegal. You cannot lock me out of HOA property." The problem was, it wasn't HOA property not anymore. Only 3 days earlier, a county judge had ruled that the trail crossed onto my land without permission and ordered it permanently closed. The court documents were still lying on my kitchen counter. My name is Thomas Mitchell. I'm a 45-year-old civil engineer who moved to Pine Ridge Estates 5 years ago precisely because my property backed onto undeveloped woodland. TPC was exactly what I craved after long days managing construction sites and traffic studies. When I bought the house, there was no trail, just beautiful, untouched forest stretching from my property line deep into the woods. I loved sitting on my back deck in the mornings, watching deer wander through while sipping my coffee. About 2 years after I moved in, the HOA decided they wanted to create what they called a premium amenity for the neighborhood. Without consulting any of the property owners whose land bordered the woods, they hired a contractor to cut a walking trail through the forest. At first, I didn't realize the trail crossed onto my property. It began innocently enough, a narrow dirt path that residents used for morning walks. I even used it myself a few times and thought it was a nice addition to the community. But then Patricia Garfield became HOA president, and everything changed. She had a grand vision of transforming our quiet suburban neighborhood into what she called a resort-style community. The simple walking trail was no longer sufficient. She wanted it widened, graveled, and lined with solar lights. She sent the HOA maintenance crew out every weekend, cutting down more trees, spreading crushed stone, and installing benches every 100 feet. That's when I decided to check my property survey. I dug out the documents from when I purchased the house and compared them to the trail's current path. To my shock, nearly 300 feet of the expanded trail ran directly across the back corner of my lot. They had been developing my private property without my knowledge or consent. I immediately called Patricia to discuss the issue. She appeared at my door the next morning wearing her trademark fake smile, the one that never quite reached her eyes. "Oh, Thomas," she said in that condescending tone she used with everyone, "you really shouldn't worry about such tiny details. The trail increases everyone's property values. Think of it as the HOA doing you a favor. We're improving your land at no cost to you." When I explained that I had not given permission for any improvements and wanted the trail rerouted, her smile vanished instantly. "The HOA has been here for 20 years, she snapped, her voice turning sharp. "That trail is a community asset, and you have no right to interfere with it. Every homeowner benefits from our amenities." I tried to explain that legal property boundaries don't change simply because the HOA wishes them to, but she cut me off. "If you have a problem with HOA decisions, you can bring it up at the next board meeting," she said as she turned to leave. "But I'll tell you right now, the board stands behind me 100%. The next board meeting was a disaster. I arrived prepared with my property survey, satellite images showing the trail's encroachment, and a folder full of legal precedents on property rights. Patricia barely allowed me to speak for 2 minutes before interrupting. "The board has reviewed your concern and found it without merit," she announced. "The trail stays where it is." Meeting adjourned. When I tried to continue, she actually had the HOA security guard escort me out of the community center. After that meeting, things escalated quickly. Foot traffic on the trail increased dramatically, almost as if Patricia was encouraging residents to use it more. I began finding litter on my property, dog waste bags tossed into my bushes, and people cutting through my yard to reach the trail from different directions. One morning, I discovered a group of teenagers had built a bonfire pit just 20 feet from my property line, using materials gathered from my land. I posted "no trespassing" signs along my boundary. The next day, they were gone. Patricia sent me a violation notice for placing unauthorized signage in common areas. When I pointed out that it was my private property, she claimed the HOA had an easement. When I asked to see documentation of this easement, She insisted it was implied by common use. That's when I knew I needed a lawyer. I hired Jennifer Russo, a property attorney who specialized in HOA disputes. She laughed when I mentioned the implied easement claim. "That's not how easements work," she said. "If there's no written agreement and no recorded easement, there's simply trespassing." We sent a formal cease and desist letter to the HOA, demanding they stop using my property and remove all trail improvements from my land within 30 days. Patricia's response was to call an emergency HOA meeting, where she proposed a special assessment to fight what she called my frivolous lawsuit. She told the entire neighborhood that I was trying to destroy their quality of life and take away their beloved walking trail out of spite. She even launched a newsletter called Trail Truth, posting weekly updates that vilified me. One issue included a photo of my house with the caption, "Where community spirit goes to die." The propaganda campaign might have succeeded if Patricia hadn't made one critical mistake. In her eagerness to expand the trail, she had also allowed it to cross onto 2 other properties besides mine. Once those owners realized what had happened, they joined my lawsuit. Suddenly, it wasn't just one disgruntled homeowner against the HOA, it was 3 property owners defending their legal rights. The case went to county court 6 months later. Patricia arrived with the HOA's lawyer, expecting to overwhelm us with what she called overwhelming community support. She had even brought a petition signed by 200 residents demanding the trail remain open. Judge Harold Brennan was not impressed. "Miss Garfield," he said, peering over his glasses at her, "you could have 1,000,000 signatures, and it wouldn't change property law. You cannot build on land you don't own without permission. Period." Our attorney presented the surveys, property deeds, and aerial photographs showing how the trail had gradually expanded onto private land. The HOA's lawyer attempted to argue for a prescriptive easement, claiming the trail had been used long enough to establish rights. The judge shut that down immediately. 2 years of unauthorized use does not create a prescriptive easement in this state, he said. You need 20 years of open, notorious, and hostile use. You have none of those elements here. The ruling was swift and decisive. The HOA was ordered to close the trail immediately wherever it crossed private property. They were required to install locked gates with "No Trespassing" signs at both ends of the affected section. Any HOA member who violated the order would face criminal trespassing charges. The judge also awarded us our legal fees, meaning the HOA would have to cover the cost of our attorneys. Patricia's face during the ruling is something I'll never forget. She went from confident to confused to furious in the span of about 30 seconds. When the judge finished speaking, she actually stood up and protested, "Your Honor, you don't understand. I'm the HOA president. I represent 200 families. You can't let one person destroy our community." The judge's response was perfect. "Ms. Garfield, I'm not destroying anything. I'm upholding property law. If you want a trail, build it on land you actually own." I installed the gate myself the next day. It was a heavy-duty steel gate secured with a commercial-grade padlock that would require serious tools to breach. I posted the court order in a waterproof frame directly on the gate, along with several prominent "No Trespassing" signs. The sheriff's department had already been notified of the ruling and assured me they would respond promptly to any violations. For the first few days, people would approach the gate, read the signs, and turn back. Some took photos, likely to share in whatever social media group Patricia was using to rally support. I monitored it all through my security cameras, waiting to see what she would try next. She didn't disappoint. She began appearing every morning at dawn, before most residents were awake. She would stand at the gate for 10 or 15 minutes, snapping photos, making phone calls, and occasionally even bringing a measuring tape, as if plotting her next move. I have footage of her peering through gaps in the fence, searching for possible alternate routes around the barrier. Then came the morning, inscribed at the beginning 6:30 a.m. Patricia in her fuzzy pink bathrobe and slippers, shaking the gate as if sheer determination could force it open. But that was merely the prelude. The following day, she arrived with several HOA board members and a pair of bolt cutters. I watched on my phone as she delivered what appeared to be an impassioned pep talk to the group, brandishing the bolt cutters like a symbol of victory. I called 911 immediately. The HOA president is about to destroy my property in direct violation of a court order, I told the dispatcher. I have it all on video. Please send officers right away. The dispatcher was already familiar with the situation, as the sheriff's department had been fully briefed on the ruling. They promised to dispatch units immediately. Patricia had just positioned the bolt cutters on the lock when the first sheriff's cruiser arrived. The deputy stepped out, and I heard him clearly through my security camera audio. "Ma'am, please step away from the gate and put the tool down." Patricia turned to him with her trademark fake smile. "Officer, I'm the HOA president. There's been a misunderstanding. This gate is blocking HOA property, and I have every right to remove it." The deputy wasn't swayed. "Ma'am, I have a copy of the court order right here. This gate is legally installed on private property. If you cut that lock, you'll be arrested for destruction of property and violating a court order." Patricia's smile finally crumbled. She launched into a rant about taxpayer rights, community assets, and how the judge hadn't grasped the full situation. A second deputy arrived, and together they spent 20 minutes attempting to explain to her that she possessed no legal authority to remove the gate. She kept insisting that, as HOA president, she enjoyed special privileges that superseded the court's ruling. Finally, when she raised the bolt cutters again and declared, "I'm doing this for my community," the deputies had no choice but to arrest her. The footage of Patricia being led away in handcuffs, still in her designer tracksuit, and full makeup at 7 a.m. became key evidence in the subsequent contempt of court hearing. The same judge, Harold Brennan, who had issued the original order, watched the security footage with a look of disbelief mixed with clear annoyance. "Miss Garfield," he said, "I thought I was clear in my ruling. No means no. Court order means court order. How is this confusing to you?" Patricia attempted to explain that she believed the order was temporary and that she was merely protecting her community's investment in the trail. The judge cut her off. "You're an HOA president, not a sovereign citizen. You don't get to decide which court orders to follow." She was found in contempt of court. The penalties were severe. Patricia was personally fined $5,000 for contempt. She was ordered to pay an additional $3,000 to reimburse me for the new gate and security upgrades I had installed. The HOA itself was fined $25,000 for its role in the ongoing violations and required to cover all legal fees for the follow-up proceedings. But the worst consequence for Patricia was still ahead. The HOA board convened an emergency meeting to address her actions. The other members were livid that her behavior had cost the association tens of thousands in fines and legal fees. The community was split. Many residents were pissed about losing trail access, but even more furious about the special assessment they would now face to cover Patricia's contempt charges. The vote to remove her as president was unanimous. Even her former allies turned against her. When the result was announced, Patricia stood up, her face flushed with rage and humiliation. "You're all cowards," she said, her voice trembling. "I was fighting for this community. I was trying to protect our property values." The board secretary responded calmly, "Patricia, you cost us over $50,000 trying to steal someone else's land. You're done." Patricia stormed out of the meeting, slamming the door so hard that the frame cracked. That damage earned her yet another $200 fine from the HOA for vandalizing community property.